Welcome to another deep dive.
Today, we are going to take a look at the U.S. federal court system.
Okay.
And get this, our source material is a pamphlet.
Okay.
And this pamphlet is designed to explain the system to judges and administrators from other countries.
Interesting.
It's like, welcome to America. Here's how our legal system works.
Yeah. It's a fascinating choice. It speaks volumes, I think, about just how unique the U.S. system is.
Right.
Many countries have a single centralized judicial system.
Right.
But the U.S. has this intricate web of federal and state courts.
Yeah.
Each with its own rules and powers.
It's like having 50 different legal ecosystems all coexisting under this one federal umbrella.
Exactly, yeah.
And the pamphlet dives straight into how the U.S. system balances federal and state powers, emphasizing this concept of checks and balances. You know, you've got Congress makes the laws, the president enforces them, and the courts interpret them.
Exactly. And this document highlights how the founders went to great lengths to ensure the judiciary's independence.
Yeah.
Particularly from political pressure.
Right.
For instance, federal judges are appointed for life, and their salaries can't be reduced.
That's a lifetime gig.
It is.
That must make a difference when you're making rulings on these high-stakes cases.
Absolutely.
Potentially involving very powerful people.
Yeah.
No need to worry about getting voted out in the next election.
Precisely, however. This doesn't mean judges are completely unaccountable.
Right.
They can still be removed through impeachment.
Right.
Though it's a complex process.
Yeah.
Plus, as we saw in that recent high-profile case, their financial records are subject to public scrutiny.
Yeah, that's right. It's a delicate balancing act, ensuring judicial independence while maintaining accountability. Now, let's dive into the types of cases that land in federal court versus state court. What goes where?
Right. So the pamphlet gives a good overview. Think international trade disputes, bankruptcy cases, conflicts between states, and anything related to the Constitution.
Okay.
These fall under the jurisdiction of federal courts.
So those big ticket items end up on the federal docket.
That's right.
What about state courts? What ends up there?
State courts handle the bulk of everyday legal matters.
Okay.
Think divorces, traffic violations,
Okay.
and most criminal cases.
Okay.
The key concept here is jurisdiction.
Right.
Which court has the authority to hear a particular case?
So a court can't just decide to take on any case it wants.
Exactly.
Even if it seems, I don't know, interesting or important.
Exactly. It needs to have that legal authority,
Right.
the jurisdiction, to make a ruling on that type of case. The pamphlet does mention that things can get complicated sometimes.
Okay.
Cases can sometimes move between state and federal courts under specific circumstances.
Right.
But it's not a free-for-all.
Right.
There are mechanisms in place to manage that.
Okay, let's unpack that journey of a case a bit further.
Yay.
The pamphlet does a great job of outlining the stages of a trial, even for someone like me who isn't a legal eagle. Let's start with civil cases. We have the initial complaint. Then what's called discovery.
Right.
What exactly happens during this discovery phase? The pamphlet mentioned depositions.
Yes.
And those sound intense.
They can be?
Yeah.
Imagine being in a room under oath
Yeah.
with lawyers from both sides grilling you with questions.
Yeah.
That's a deposition in a nutshell.
Okay.
It's a key part of that discovery process.
Right.
Where both sides are gathering evidence before a trial.
Right.
It's all about uncovering the facts.
Yeah.
And let me tell you, things can get very revealing, even contentious during these depositions.
No wonder they make for such compelling courtroom dramas.
Me too.
Now, the pamphlet also mentions motions
Yeah,
and settlements.
right.
It seems like those come up in almost every legal case that you hear about.
You're right. They are incredibly common.
Yeah.
So a motion is basically a formal request
Okay.
made to the judge for a specific ruling,
Okay.
like dismissing the case altogether or asking for more time.
Okay.
A settlement, on the other hand, is when the parties involved agree to resolve their dispute outside of court,
Okay.
reaching a compromise before a trial even begins.
So you're saying a large number of these civil cases never even make it to trial?
You're absolutely right. The vast majority of civil cases are either settled out of court
Wow.
or dismissed
Yeah.
for various reasons before they reach a full-blown trial.
That's fascinating. So what about criminal cases? How do they differ?
Well, with criminal cases, things get a bit more serious, as you can imagine.
Right.
The grand jury plays a critical role
Okay.
in determining if there's even enough evidence to charge someone and proceed to trial.
And this pamphlet mentions that a staggering number of criminal cases, over 90%, actually end in plea bargains.
Wow.
It seems like going to trial is almost the exception, not the rule.
Yeah.
Even in criminal court.
That's right. Plea bargains are a cornerstone of the criminal justice system.
Yeah.
Though they often spark debate.
Right.
The pamphlet does emphasize that the judge plays a crucial role in ensuring any plea bargain is fair.
Right.
And that the defendant fully understands the implications of their plea.
So it's not just a rubber stamp. There's still judicial oversight involved.
Absolutely.
And of course, in criminal cases, there's that much higher standard of proof.
Yes.
Beyond a reasonable doubt.
Exactly. It underscores the gravity of potentially taking away someone's freedom.
Right.
Unlike civil cases that often revolve around financial matters.
Right.
The document highlights how this higher burden of proof is a fundamental difference between the two. Now, shifting gears to a broader perspective, the pamphlet also delves into this concept of the adversary system.
This sounds intriguing. What's the gist of the adversary system?
It essentially means that it's not the judge's responsibility to uncover evidence or build a case.
Okay.
Instead, it's up to the two opposing sides to present their strongest arguments and evidence with the judge acting as an impartial referee.
Right.
Ensuring a fair fight, so to speak.
So it's like a legal boxing match.
Yeah.
But hopefully with less bruising.
Right.
Each side comes prepared to deliver their knockout punch.
Exactly.
What happens if one side doesn't agree with the judge's decision?
That's where the appeals process comes in.
Okay.
There's the document in some detail.
Yeah.
A case can move up the judicial ladder from a lower court to a higher court.
Right.
Potentially all the way to the Supreme Court.
Speaking of the higher-ups, I was fascinated by this section on judicial administration.
Okay.
I had no idea each federal court had so much autonomy.
Yeah.
They manage their own staff, budgets, even their technology systems. It's like they're running their own mini organization.
It's a remarkable degree of decentralization, which the pamphlet suggests is crucial for ensuring each court operates efficiently and responds to local needs. The chief judge of each court plays a pivotal role in this, acting as both a judge and an administrator.
So they're presiding over trials and making sure the courtrooms have enough Wi-Fi bandwidth?
That's right.
That's multitasking.
Yeah.
But seriously, that's a lot of responsibility. They must have support systems in place.
Absolutely. The pamphlet highlights other key players like the judicial councils that provide oversight within their circuits and handle complaints of misconduct. Then there's the Judicial Conference, which sets policy for the entire federal court system. Think of them as the governing body.
It's like a whole other branch of government.
It is.
Just focus on the courts. But when you consider the sheer scale, nearly 100 different district courts.
It's a lot.
It makes sense to have a system for keeping things running smoothly and consistently. What I found really surprising was how the courts handle their budget.
Yes, the pamphlet explains that the federal court system has a surprising degree of budgetary independence.
Interesting.
They submit their budget requests directly to Congress.
Wow.
Without going through the president's office.
Really?
This separation is meant to further insulate the judiciary from political influence.
That's a bold move.
It is.
Most government agencies would love that kind of direct line.
I would think so.
To the people holding the purse strings, it really drives home that commitment to an independent judiciary. And speaking of independence, this detail blew my mind. The federal court system even has its own IT department.
It makes sense when you think about it.
I guess so, yeah.
The courts handle vast amounts of sensitive information.
Right.
And they've been early adopters of technology.
Okay.
Dating back to the 1970s, as the pamphlet mentioned.
Wow, going way back.
It's all about improving efficiency, transparency, and public access to information.
I'm just hoping they've upgraded from dial-up internet since then. Okay, one last thing that really stood out to me. The document emphasized the importance of courthouse design.
Interesting.
I never realized how much thought goes into the look and feel of these buildings. It's not just about aesthetics, is it?
You're right. It's about creating spaces that project an image of dignity, solemnity, and, importantly, accessibility.
Okay.
There's actually a U.S. Courts design guide dating back to the 1980s.
Wow.
That set standards for everything.
Wow.
From courtroom layouts to the materials used in construction.
So it's about more than just picking out a nice shade of beige paint. They've really thought this through.
Absolutely. The design of a courthouse sends a powerful message.
Yeah.
About the values of the justice system.
Right.
It's fascinating how much attention is paid to these details.
This pamphlet has been a treasure trove of information.
It has.
It's given us a really comprehensive look
It has.
at the intricacies of the U.S. federal court system. But one question keeps popping into my mind.
Okay.
And it's something the pamphlet doesn't directly address. This pamphlet was clearly written before social media and the 24/7 news cycle really took hold. I'm curious, how has this constant flow of information, the online commentary, the potential for things to go viral, impacted the courts? It's got to be a whole new world for judges trying to maintain impartiality.
Yeah, it's a fascinating issue and a complex one. One that the pamphlet, understandably, doesn't really delve into.
Right.
On one hand, technology has the potential to enhance transparency and public understanding of the judicial process.
Yeah.
We're seeing more live-streamed proceedings.
Right.
Easier online access to court documents.
Yeah.
All of which can demystify the legal system for the average person.
It's like bringing the courtroom to people's living rooms.
Exactly.
Giving them a front row seat to, how justice is administered. But I imagine there's a flip side to this increased accessibility.
Exactly. The constant buzz of social media,
Yeah.
the instant analysis, the potential for cases to become media sensations before they even reach a courtroom.
Right. Yeah.
It all creates new challenges for maintaining judicial impartiality.
It's got to be tough to find impartial jurors when a case has been, dissected and debated endlessly online.
You're hitting on a critical point.
Yeah.
Jury selection becomes even more complex in the age of social media.
Right.
And it's not just about finding jurors who haven't formed an opinion.
Right.
It's about finding jurors who haven't been exposed to such a volume of information, accurate or not.
Right.
That it could potentially bias their judgment.
And what about the judges themselves? They're human.
Right.
They're online.
Right.
They see the headlines. They see the hot takes.
Of course.
How do they navigate that constant pressure cooker of public opinion?
It's a valid concern.
Yeah.
And one that legal scholars are grappling with.
Right.
The judicial oath emphasizes upholding the Constitution.
Right.
And applying the law impartially.
Right.
But it's a tall order when external pressures are so amplified.
Yeah.
And ever-present.
It sounds like the digital age has created a whole new set of challenges.
It has.
For the U.S. federal court system.
It has, but it's also important to remember that this system is designed to evolve.
That's true.
Throughout its history, it is adapted to changing social norms, new technologies, shifting public expectations, the core principles of judicial independence, fairness, and the rule of law remain paramount.
It's reassuring to know that even in the face of these new challenges, the system is designed to endure and uphold its core values.
Precisely. This pamphlet provides a foundational understanding of the U.S. federal court system.
It does.
But it's crucial to remember that it's a living, breathing entity, constantly adapting and responding to the world around it.
So what's the takeaway for our listeners? What's that one big provocative thought they can carry with them?
Well, the U.S. federal court system is a complex and fascinating mechanism designed for a delicate balance, upholding individual rights while ensuring a just society, all within a framework of, carefully constructed checks and balances. As we move further into this digital age, the courts will undoubtedly face new challenges, but their ability to adapt and evolve will be crucial for the very fabric of American democracy.
It's a good reminder that these systems, however complex or even imperfect, are constantly evolving.
They are.
Just like our understanding of them. Thanks for joining us on this deep dive into the U.S. federal court system. Until next time, keep exploring, keep questioning, and keep those deep dives going.